Welcome to the other side of Lucy Letby. In episode 59, we're going to continue with my analysis of the Court of Appeal ruling against Lucy Letby, denying her the right to appeal. And we'll continue where we left off. Ground 3, the judge's direction on harmful acts. Paragraph 152, Ground 3 argues that the judge was wrong to direct the jury that they did not have to be sure of the precise harmful act or acts before they could convict on a particular count. Paragraph 53, as is usual, the judge discusses his proposed directions of law with counsel. On behalf of the applicant, Mr. Myers submitted that the jury should be directed that they could not convict the applicant of any count unless they were sure of how the baby concerned had been harmed. He argued that the counts of the indictments were specific to time and place. They were, for the most part, based on one or more alleged mechanisms of injury, which had been the subject of detailed evidence. The case had been opened and the evidence adduced on the basis of those allegations as to the mechanism of injury. And the jury had to be sure of the requisite intention and of causation, each of which required them to identify what had happened and when. He further argued that a direction which permitted the jury to convict without being sure of the specific harmful act or acts risked the jury wrongly convicting on the basis of the applicant's presence alone, a risk which would be exacerbated by the anticipated direction as to cross-admissibility. Paragraph 154, the judge did not accept those submissions, although he did amend his initial draft of his proposed direction. Ground 3, the judge's direction to the jury. Paragraph 155, the judge directed the jury as follows. If you are sure that someone on the unit was deliberately harming a baby or babies, you do not have to be sure of the precise harmful act or acts. In some instances, there may have been more than one. To find the defendant guilty, however, you must be sure that she deliberately did some harmful act to the baby, the subject of the count on the indictment, and that the act or acts were accompanied by the intent and, in the case of murder, was causative of death, as set out in the section below, directions of law relating to offences. So we jump in there. I'm reading this for the first time, and the first thing that strikes me is that this has got to be the widest application possible for the determination of murder. You don't need to know how they did it, just that they did do it. But also, I have a problem, and I think the judge has a problem, with the term causative of death, as set out in the section below, directions of law relating to offences. So we'll look at that when we reach it. Paragraph 156. Although this is the only passage which is challenged in Grounds 3, it may be noted that in a later direction, the judge explained the legal ingredients of the offences of murder and attempted murder, saying in relation to the former, in the case of each child, without necessarily having to determine the precise cause or causes of their deaths, and for which no natural or known cause was said to be apparent at the time, you must be sure that the act or acts of the defendant, whatever they were, caused the child's death, in that it was more than a minimal cause. The defendant says that she did nothing inappropriate, let alone harmful, to any child. Her case is that the sudden collapses and deaths were or may have been from natural causes, or for some unascertained reason, or from some failure to provide appropriate care, and were not attributable to any deliberate harmful act by her. And I think even at this stage now, that paragraph by the original judge directing the jury is, for me, in tatters, absolute tatters. As I've said so often, anyone with any medical reading this so-called evidence, expert evidence, knows that these babies were a heck of a lot more sick than the prosecution wanted to admit. Born in good condition is certainly not a phrase that I would say 99% of doctors would apply to any of these babies. Some of the poor babies indeed were born on the very edge of viability. And by their very nature at that time, They were vulnerable to death and therefore could not have been born in good condition. And then ground 3, the submissions to this court, paragraph 157. In support of this ground of appeal, Mr. Myers repeats his argument that in the circumstances of this case, in which the prosecution relied on witnesses who put forward specific causes of harm and rejected other explanations suggested by the defence, the jury should have been directed to decide whether they were sure that the prosecution had proved the specific mechanism of harm which had been alleged in relation to each individual child. He further reiterates that it was necessary for the jury to be sure of the precise mechanism by which harm was caused before they could be sure of the alleged intention and before they could safely eliminate other possible explanations for a baby's collapse or death, such as natural causes or suboptimal care. In relation to the need to exclude natural causes as possible cause of collapse or death in an individual's case, he refers to R versus Canning, in which this court observed that the exclusion of currently known natural causes of death does not of itself establish that a death or deaths resulted from a deliberate infliction of harm, as said in paragraph 22, that what may be unexplained today may be perfectly well understood tomorrow. And that in R.V. Holdsworth, in which the court said at paragraph 57, but particular caution is needed where the scientific knowledge of the process or processes involved is or may be incomplete. As knowledge increases, today's orthodoxy may become tomorrow's outdated learning. It seems to me that Benjamin Myers is trying to make the case that science may somehow ride to Lucy Letby's rescue in the future, that we will make some exciting discoveries that will eventually lead us to a different conclusion in the Letby case. And for me, this is what American footballers would call the Hail Mary pass. You just throw the ball anywhere and pray that it goes where you want it to. It's a very weak argument because the natural causes of death proven by postmortem and evident from the trial itself are already in place, and we don't need some future discovery to make that clear. The babies were never stable, to use their phrase, and in my opinion as a doctor, had the jury understood just how sick these babies were, they would never have convicted Letby, because they've now opened the entire nursing profession to a similar charge against another unknown nurse in the future. And then to paragraph 158, count 17, concerning baby N, Dr. Evans said in evidence to the jury that he was unable to exclude her embolus as a cause of the baby's collapse, whereas Dr. Bowen felt that the baby had suffered the infliction of a painful stimulus, although there was no visible injury. So all the doctor has to do now is think that something happened. We don't need any evidence that it happened. And again, I asked you what you would think if medicine was practiced that way. Mr. Myers relies on that as an indication that jurors may have reached their verdict by differing routes. He submits that the direction given by the judges gave rise to risks that the jury may wrongly treat the applicant's presence on the unit at a particular time as sufficient in itself to establish her guilt, and or that the jury might convict in circumstances where there was no sufficient agreement as to the basis on which they reached that verdict. He makes the further point that in the light of the judge's direction as to cross-admissibility, the jury, having reached a guilty verdict by differing factual routes, would then have been permitted to use that verdict as support for the prosecution case on other counts. And in paragraph 159, the respondent submits that the judge's direction was correct. Mr. Johnson accepts that the prosecution were required each of the legal ingredients of the charges of murder or attempted murder, but submits that they did not have to prove the precise or any mechanism by which death was caused or attempted. And he refers to cases in which the prosecution had been able to prove murder even though the body of the deceased has never been found, and the cause of death was therefore unknown. And then he gives a citation which I can't even pronounce, and then he refers to the decision of R.V. Brown and R.V. Ames, AMES. In the former, R.V. Brown, it was held that a jury must agree on every ingredient of the offence charged before they could convict, and the jury must be directed accordingly. In the latter, it was held at paragraph 40 that subsequent case law has established, quote, a clear distinction to be drawn between a matter which is, one, an ingredient of the offence, and two, a merely evidential or ancillary issue. It is common ground that on the latter there is no need for jury anonymity or a Brown direction, BROWN. But straight away, before we look at these cases, we have to say that quoting a case in which the body wasn't found is irrelevant to the Letby case, because not only were the bodies found in the Letby cases, but they were subject to post-mortem as well. So for me, it's a very weak argument. Both of these cases that he cites, that Johnson cites, are fraud cases. And again, this is particularly important in the Letby case because the expert witnesses claimed that Letby had harmed baby with intent to kill by overfeeding or injecting air into the stomach. This is not a recognized medical condition, I would argue. There are no cases in the literature that describe any baby being harmed by either overfeeding or having air pushed into the stomach. And again, we have no evidence that air was injected into the stomach. None, zero, because air gets in by nasogastric tube, by swallowing of air, and from ventilation. And it's a very common finding in a preterm neonatal ward. Something, again, which was not explained to the jury. So we get to paragraph 160, which is ground 3 discussion. So this is the appeal court judges. The distinction referred to in R.V. Ames is well established, provided the jury or the requisite majority are sure that all of the legal ingredients of the offence charged have been proved. It is not necessary for them all to reach their decision by precisely the same route. To take a simple example, if on a charge of assault occasioning actual bodily harm, the jury was sure on the evidence that the defendant unlawfully punched and or kicked his victim, thereby causing him actual bodily harm, it is not necessary for the jury all to be sure of the nature of the blow or blows which caused the injury. But again, that's a false premise. Everybody knows that blows, punches, kicks are 1, intentional, and 2, are capable of causing harm, and 3, came from a known source. In other words, the jury knew who threw the punch. That's not the case with air in the stomach or the source of air that allegedly created the air embolism. There are multiple sources for that, as we've said. So this argument for me fails to meet the first part of this Ames case. That is that the defendant, Letby, did anything unlawful because we have no witnesses. And even, as I say, if we all agree that the babies did have air emboli, we cannot know where that air came from when the babies are subject to multiple sources of that air, which all of them were. And in paragraph 61, when issues of this kind arise, it is important to remember that in R.B. Brown, the case put forward by the prosecution gave rise to a very specific problem. The defendant was charged on indictments with offences of fraudulently inducing investments of money. The particulars of each count alleged that he had induced his victims into entering into an agreement by knowingly making a number of false statements. The judge directed the jury that as long as they were all agreed that a dishonest inducement had been made, it would not matter if some jurors were sure that the first false statement was made, some were sure that the second false statement was made, etc. In the circumstances of that case, however, disagreement between jurors as to whether a particular false statement was made meant there was necessarily also disagreement as to whether the essential ingredient of a fraudulent inducement was proved. And again, the jury was misled, in my opinion, by the medical evidence in this trial into believing that there was no other explanation for the sudden collapse and death these babies. And we come back to that time and time again. There are explanations for all of the deaths of these babies, and they were not sudden and unexpected. And I think and hope that by this judgment here, which has clearly thrown each of Letby's offences into one grand conspiracy, it will only require the removal of one of those offences to unravel this conspiracy. And they carry on in the same vein, paragraph 162. The circumstances in which a Brown direction is required, therefore, arise only comparatively rarely. See R.V. Chilvers, which the court stated at paragraph 63 that the need for the Brown direction, quotes, is confined to those cases when, first, there is an appreciable danger that when the jury is deciding whether they are agreed on the matter that constitutes the relevant ingredient of the offence, some may convict having found a particular matter proved as constituting the ingredient, while others may find a wholly different matter or different matters proved as constituting the ingredient. Therefore, when the factual basis of the crime charged, example, as set out in the particulars, are in reality individually coterminous with an essential element or ingredient of the offence, then it appears it is necessary for a Brown direction to be given. This, it is to be emphasised, does not require each juror to follow the same route through the evidence to reach the decision that a particular ingredient is made out. Secondly, a Brown direction should be given when two distinct events or incidents are alleged, either of which constitutes the ingredient of the offence charged. Third, a Brown direction should be given when two different means of committing the offence may give rise to different defences. And if I understand that correctly, Dowie Evans has since changed the events or incidents alleged, and therefore the Letby jury should have been subject to a Brown ruling because Dowie Evans has changed his mind that Lucy Letby didn't cause harm at all to BBC by means of injecting air into the stomach. That's equivalent to the kick or the blow. And therefore, for me, that offence doesn't exist anymore. It's been changed to air embolus, which is distinctly different from a punch or a blow or the injection of air into the stomach. It would appear to me, logically, but I'm not a lawyer, that this is the very ingredients, indeed, to use their word, of an unsafe conviction. These judges made this ruling before Dowie Evans changed his mind, and therefore, by that fact alone, this interpretation of the law is no longer applicable to Lucy Letby. The jury, logically, is now back in the position where they don't know if any kick or blow was thrown at the victim. And in 163, we go on to elaborate on that, I think. An example of the third category mentioned in that passage is provided by R.V. Carr, Leslie Joseph 2000, where there was an issue as to whether the fatal blow was a kick to which the defendant's defence was identification or a punch to which his defence was self-defence. It was held that in the circumstances of that case, the jury needed to be directed that they must agree on the basis of the conviction. Paragraph 164. In this present case, the prosecution was required to prove that the applicant had killed or attempted to kill a baby by a deliberate and unlawful act or acts. Expert evidence was given as to the nature of the harm or combination of harm which the applicant was alleged deliberately to have inflicted or attempted to inflict in each case. For example, the causing of an air embolus, or the damaging of a baby's liver, or the administration of insulin. The prosecution relied also on other relevant facts and circumstances, such as the applicant's writing of a note which appeared to be a confession, her retention of trophies and confidential documents, her presence at the time and place when most of the sudden collapse occurred, the fact that a number of babies concerned suffered a catastrophic collapse only a very short time after their designated nurse had briefly left the room, and the fact that siblings suffered harm at or about the same time as each other. The defence to each charge was a denial that the applicant had deliberately committed any unlawful act which caused or attempted to cause fatal harm. The defence raised but adduced no affirmative evidence of other possible explanations for the collapse or death. The jury were directed as to the need to exclude those other possibilities before they could convict. And paragraph 165, Mr. Myers' submissions do not persuade us that it was necessary before the jury could exclude those other possibilities that they must all agree on the precise act or acts which the applicant committed. The issue for them was whether the evidence as a whole drove them to the conclusion that the applicant, by a deliberate and unlawful act or acts, had inflicted harm which caused or contributed to the baby's collapse or death. In paragraph 166, in the circumstances of this case, the judge was accordingly correct to direct the jury that they must be sure on the evidence as a whole that the applicant had deliberately done something to harm the baby with the requisite intent for murder or attempted murder, and in the case of those babies who died, that her act or acts had caused or contributed to the death. It was not necessary for the prosecution to prove the precise manner in which she had acted. To impose such a burden on the prosecution would be wrong in law, as the single judge said it would confuse proof of the relevant fact that harm had been deliberately caused with the evidential route encompassing all of this circumstantial evidence, not merely the medical evidence, for which the fact could be proved. That may be illustrated by the reflection that, taken to its logical extreme, the defence submission would appear to mean that the jury would not have been entitled to convict if, in addition to the evidence adduced by the prosecution, the applicant had given evidence admitting that she had intentionally and unlawfully killed the baby, but declined to say how precisely she had done so, which is what we call in logic a hypothetical. She didn't say that. Again, all I have to say to this is there are perfectly simple and understandable reasons that could have explained to the jury the how, what, where, why, and when of all of these convictions. And in order to sustain the conviction against Lucy Letby, it's essential that the prosecution sustains the argument that the babies were stable, born in good condition, etc., and all of the superlatives that they used throughout the trial to describe these babies' health. And my argument is, or at least part of my argument is, that these claims are not sustainable and were only made so by the extreme opinion of the expert witnesses, particularly Evans and Bowen. For example, to say that a baby breathing very fast within 36 hours of birth was an indication that the baby was stable because the rate of breathing didn't increase. It had already increased. And as I've said before in other podcasts, if these experts had said these same things in a professional examination, they would have failed the professional examination. A baby with an elevated respiratory rate can never be stable. Don't make it any more complicated than that. And in paragraph 167, for those reasons, ground 3 are not arguable. And again, I find this very confusing. The defence in the case of Orr versus Carr did not dispute the fact that their client had kicked and punched the alleged victim. Instead, they tried to make a legal argument that the jury couldn't know which of the injuries, the kick or the punch, caused death. So for me, this isn't comparable at all to the Letby case. Letby denied inflicting any harm. No one witnessed her harming any baby, and all the babies that she's supposed to have killed had postmortem findings for which the diagnosis of air embolism was wholly unsupported. How is that even remotely connected to this Orr versus Carr case? And the judges have said in paragraph 164 that it was the expert evidence given as to the nature of the harm or combination of harm. For example, air embolism or damage to the baby's liver or the administration of insulin, for which there is no proof whatsoever. And it seems, therefore, that the judge's reasoning in the Court of Appeal, as far as I'm concerned, is not necessarily unfair, but was corrupted by the admission into evidence of very bad scientific and medical evidence, which fails to meet any kind of standard as to its methodology. And remember, from paragraph 147, the judges have in effect admitted to this corruption. And by corruption, I don't mean any intentional act on the part of the judges. I mean logically corrupt. The judges made a mistake, in my opinion, when they said in paragraph 147, nor are we able to accept the submission on behalf of the applicant, Letby, to the effect that the expert witnesses wrongly based a diagnosis of air embolism solely on an exclusion of any other possible cause. And that's untrue, because the methods by which we diagnose air emboli, CT scan and postmortem techniques, weren't applied to the babies. The diagnosis was 100% diagnosis by exclusion. And oddly enough, in this paragraph, the judges don't give any examples of a positive finding of air embolism in these babies. But they do say that the argument of other possible causes would carry more weight if any witness had given evidence to the effect that he or she could not identify any other possible cause of the baby's collapse, and therefore assumed on that basis alone that the baby's collapse must have been due to air embolism. Evidence to that effect might well be criticized as mere conjecture, but the submission on behalf of the applicant did not persuade us that there was any instance of whether either Dr. Evans or Dr. Bowen gave such evidence. So again, the judges aren't doing anything wrong here. What they're saying is that the experts effectively ruled out any other possible cause of death, which is at the heart of this Lucy Letby case problem. And it doesn't hang together, even from the trial transcript. Dowie Evans, for example, in the case of baby O, claimed that the liver injury occurred in the morning when Lucy Letby was attending the baby, and that miraculously somehow this baby with a very severe traumatic injury to the liver, equivalent, according to Dr. Marnarides, of a road traffic accident, that baby managed to struggle on throughout the day, showing no signs of a liver injury, which is impossible. And moreover, in the postmortem findings, as I've said before, the blood found in the peritoneal cavity, that's the membrane holding together all of the intestinal organs, was unclotted. Unclotted blood only occurs at the time of death. Unclotted blood couldn't be present in the peritoneum from an injury inflicted earlier in the day. That blood would be clotted, at least to some degree. And it's very easy to distinguish clotted from unclotted blood, because unclotted blood doesn't contain a protein called fibrin, but clotted blood does. And once fibrin forms in a clot, it stays there. Even if that clot were to re-liquefy as part of the postmortem changes in the body, it would still contain fibrin. The fact that it was unclotted means it did not contain fibrin and therefore happened at the time of death. That is how weak and tenuous this evidence against Lucy Letby is. But the judges sadly don't know that, because her defence was so awful. And in that same paragraph, the judges said that Bowen and Evans considered were appropriate whether the collapse may have been due to natural causes, but concluded for reasons which they explained that it was not. But looking through the publicly available transcripts anyway, they didn't explain why something didn't happen. They just made claims that it didn't happen. For example, in baby D, the postmortem found pneumonia with acute lung injury. Pneumonia is an infection. It wiped out half of the baby's lung capacity by destroying at least one lung. Therefore, it must have started in the womb, because baby D died 36 hours after she was born. And the mechanism of death from the pneumonia was acute lung injury, which is a hyperinflammatory response that occurs because of the infection and is made worse by the use of oxygen and mechanical ventilation to treat the infection. But the infection only got as bad as it did because BBD didn't get antibiotics when the membranes had ruptured. That is a very simple and easy way to explain how BBD died. And I can't understand why an expert wouldn't see that, but claim instead that the baby died with pneumonia, not from pneumonia. Yes, but even if the baby died with pneumonia and not from pneumonia, the baby fundamentally died because of acute lung injury, which was from the pneumonia, not with the pneumonia. All of this, no doubt, will be revisited. It's a question of how quickly it will be revisited. But I can't see either how these grounds that the judges have used to sustain the conviction are not now fatally altered by the fact that Dowie Evans has changed his mind as to the mechanism of, does that not put us back into the territory of distinguishing kicks from punches? Because the mechanism of death are injected into the stomach that Evans has since abandoned is not a recognized cause of death or mechanism of death in pathology. He invented that, as he admitted to Rachel Aviv in her article. And having invented it, he's now abandoned it, saying that it destabilized the baby, but wasn't the cause of death. I wonder what kind of legal Houdini act can rescue the conclusions of this Court of Appeal document from that. I don't know. So the whole Court of Appeal reasoning to me is a logical death trap when it's viewed in the light of proper evidence. But oddly enough, it's also an easy trap to get out of for the judges, as far as I'm concerned, because they've been misled too, in my medical opinion. And that's all I intend to make on these podcasts, an opinion based on my medical knowledge and understanding and experience. Anyone's entitled to argue against me, but so far no one has, which I find very odd. But anyway, we'll proceed on through this now. Proposed ground 6, fresh evidence. Paragraph 168. It is convenient to deal with this ground of appeal next. The applicant applies pursuant to Rule 36.14.5 of the Criminal Procedures Rule and Paragraph 10.4.5 Criminal Practice Direction for leave to vary her grounds of appeal by adding ground 6, which contends that the effective evidence of Dr. Lee, in conjunction with the weakness of the scientific evidence relied upon by the prosecution at trial to prove her embolism, is such as to render the convictions on counts 1, 2, 3, 4, 5, 12, 16, 17, and 20 unsafe, and thereby also to determine the safety of convictions on counts 6, 7, 8, 15, and 21. 169. The applicant seeks to adduce as fresh evidence pursuant to Section 23 of the Criminal Appeals Act 1968, Section 23, a report by Dr. Lee dated 10th of March 2024, together with the 3 annexes thereto, and a further report dated 26th of March 2024, together with one of the several annexes thereto. It is submitted that this evidence provided support for the applicant's contention that Dr. Evans and Dr. Bowen wrongly used skin discoloration as a means of diagnosing our embolism. And again, I would say that that is entirely the wrong argument to make. And it just shows to me again that the defense were really out of their depth here. The argument is very straightforward. Dowie Evans had put into evidence, which is included in this Court of Appeal judgment, the mechanism by which the Letby error, let's call it, caused death. That is a disorder called venous error embolism. The Lee and Tanswell paper, on the other hand, is all about a disorder called pulmonary error embolism. The two aren't even remotely connected, except by the fact that both require the presence of error in the vasculature, but for entirely different reasons. And 170 At page 6 of his first report, Dr. Lee explained why an infant suffering an air embolus becomes pale and then cyanosed blue, as the skin and organs in the body are deprived of blood supply and oxygen. He continued, since the air bubbles are quickly absorbed and disappear, the effect is transient, often lasting only seconds or minutes. Consequently, the pale or white skin discoloration are often described as migrating as patches appear and disappear. However, pale or white patches of the skin are non-specific and can also be due to transient blood vessel dilation and contraction of the skin caused by other conditions. Example, hypothermia, sepsis, allergy, virus, immune reaction. It is very difficult, if not impossible, to distinguish pale or white skin discoloration due to air embolus from other causes. The only skin discoloration that is specific to air embolus is bright pink vessels against the generally cyanosed cutaneous background. Reference Lane Tanswell, 1989. Air embolus can occur without any skin discoloration. Paragraph 171, it is submitted on behalf of the applicant that the proposed fresh evidence would be relevant both to grounds 2 and grounds 6. The core point raised by this evidence it is submitted is that prosecution witnesses wrongly diagnosed air embolus on the basis of a variety of skin discolorations, whereas Dr. Lee's evidence establishes that only bright pink vessels against the generally cyanosed cutaneous background is truly diagnostic of air embolus. Mr. Myers accepts that other types of discoloration may be evident in cases of air embolus, but submits that on their own they cannot enable that diagnosis to be made, because it would be necessary first to exclude other possible causes of a respiratory problem or a deficiency of oxygen, which again is entirely the wrong argument. If we accept that Lee's sign is a real sign in medicine, that's the bright pink flitting rash or skin discoloration, we have to also accept that Dr. Lee's attribution as to the cause of that sign is also accurate. And Dr. Lee says that that sign was attributed to the oxygenation of hemoglobin in the vasculature adjacent to the air bubbles. And I say that's not the case. And again, let's keep it very simple. The oxygenation of hemoglobin occurs at a molecular level. And it wouldn't matter if it was 1 mil or 1 liter of oxygen. The human eye cannot see anything happening at a molecular level. The molecular level is 1,000 times smaller than the human eye can see. And if we were actually seeing the oxygenation of blood in the vasculature, it wouldn't be pink. It would be the change of one shade of red to another shade of red. For me, they've got this all wrong. And in paragraph 172, the court having indicated that the proposed fresh evidence would be considered de bene esse, which in Latin means for what it's worth, but which in the law means, with regards to evidence, as I understand it, that the judges are provisionally taking on board what Dr. Lee has said, so that they're going to test his argument. And they carry on that Dr. Lee gave oral evidence by video link from Canada. And in paragraph 173, Dr. Lee is a neonatologist and health economist at the University of Toronto and one of the authors of the Lee and Tanswell paper. He has long experience of pediatric and neonatal medicine. He is, as the respondent readily accepted, eminent in his field. He explained how reduced oxygen and reduced perfusion of the skin may lead to a baby's skin displaying pallor, cyanosis, and mottling. Air embolus is one of many causes of a reduction in flow of blood in the area of the skin. It causes circulatory collapse, which in turn results in the discoloration of the skin. Because they may have many causes, pallor, cyanosis, and mottling of the skin are not in themselves diagnostic of air embolism and should not be used alone to make that diagnosis. He stated that the only cutaneous sign which is itself sufficient to make the diagnosis in a baby is the bright pink blood vessels superimposed on blue skin, which was observed in one of the cases which he reported in the Lee and Tanswell paper. He notes that similar skin discoloration was also observed in one case in Korea, reported by Dr. Myo Jin Kim and others in a 2009 paper, a case of pulmonary vascular embolism in a very low birth weight infant with massive hydrops. And hydrops vitalis, as it's called, is a severe, life-threatening condition in fetuses or newborns, and is characterized by the accumulation of fluid in at least two fetal compartments, like the abdomen, ascites, or around the heart, pericardial effusion. And there are different classifications of hydrops vitalis. It carries on. Dr. Lee doubted if this observation was exactly the same as the case which he saw. Dr. Lee explained that this discoloration occurs because the baby is deprived of oxygen. The baby's skin therefore turns blue. When air escapes from the heart, it causes blood vessels to turn pink against the blue background. The discoloration does not last long because within a few minutes the oxygen diffuses into the body. And again, I say to you, deoxygenated or oxygenated blood is always red, not blue or pink. And given that this is such a tenuous supposition on the part of Dr. Lee, it's meaningless in terms of medical evidence. And in my opinion, it's wrong in terms of scientific evidence. Human blood only looks pink because of the nature of the white light that is reflecting off the skin. It has nothing whatever to do with the nature of the blood itself. And therefore this evidence isn't of much use as far as I'm concerned. In his second report, Dr. Lee considered, this is paragraph 147, Dr. Lee considered 64 cases of air embolus in neonates which had been reported since he wrote the 1989 paper. As with his review of cases in 1989, he again found skin discoloration in about 10% of cases. He reiterated his view that only one type of skin discoloration can be diagnostic of air embolus. And again, that is entirely wrong, 100% wrong. Can possibly be diagnostic of pulmonary air embolism because air embolism is not a single disorder. I wonder how many times I'll have to say this. If you have raised troponin indicating heart muscle damage, is it because of an infarct or myocarditis, for example? We don't know because the raised troponin is probably too limited to tell us. If the troponin is very elevated, it's extremely unlikely that it's due to myocarditis. Therefore, we need a second test to be sure. That's how medicine works. And it's important that we classify the diseases properly because the treatments and the outcomes are very different for myocarditis and myocardial infarction. Paragraph 175. In his oral evidence, Dr. Lee stated that air embolus is a very rare and specific condition and should not be diagnosed by excluding other causes of death or collapse, concluding that it must be a case of air embolus because nothing else could be found. That's just too obvious to a doctor, but means nothing, apparently, to judges. Paragraph 176, Mr. Myers submits that the criteria in section 23 are satisfied. He argues that the proposed fresh evidence is clearly capable of belief. It supports ground 2, so provides a basis for allowing the appeal, and it would have been admissible at trial. As to why it was not adduced at trial, he contends, as Myers, that it was only as the trial progressed that the prosecution experts began to rely upon a wide variety of skin discoloration as a basis for diagnosing air embolism, thereby departing from their initial apparent acceptance that the only skin discoloration which would properly be regarded as diagnostic was the bright pink vessels against the generally cyanose cutaneous background, noted in one case described in the Lee and Tanswell paper. For that reason, the evidence was not available to be deployed at the time when it would have been required, and it was only after the trial that thought was given to seeking evidence from Dr. Lee. Well, we know what the judges are going to say here, but what does it say to me? Did Lucy Letby get a defense at all? If it's only during the trial and after the trial that the defense cottoned on to this use of skin discoloration as proof of anything, I can't but wonder what was the level of their preparation. Paragraph 177, the respondent, that's Mr. Johnson, submits that the proposed fresh evidence, being defense evidence, cannot be relevant to ground 2, nor it is submitted is it capable of giving rise to a ground for allowing the appeal, because it isolates the subjective observations of the various witnesses as to the skin discoloration which they saw in individual cases and takes no account of all the other evidence relied upon by the prosecution, including evidence repeatedly given by doctors and nurses to the extraordinary nature of the sudden collapses and deaths of the babies concerned. In doing so, it is argued, the applicant treats as a paradigm what was no more than a single case noted in the Lee and Tanswell paper, which itself was no more than an observational study and was criticised for that reason in the defence cross-examination of Professor Arthurs. Isn't that truly extraordinary? And what was the basis of Professor Arthurs' finding of an unusual line of gas on a post-mortem X-ray? His own observational study, which, if anything, is even worse than the Lane Townswell observational study in terms of evidential basis. Mr. Johnson emphasises that the prosecution expert witnesses did not treat skin discoloration as in itself diagnostic of our embolus, but instead took it into account as consistent with our embolus and adding to the other clinical circumstances which excluded other possible causes and pointed to that diagnosis. He argues that the prosecution case did not change in this regard and submits that the applicant could and should have called Dr. Lee at trial if he wished to rely on evidence from him. Yeah, the applicant should have called a lot of people to the trial. We're going to leave the next paragraphs to the next episode because they're quite long and I couldn't fit them into this episode. But looking at this, it's a really torturous process for me because I can see why the babies died. And it's so obvious to anyone who's practiced medicine that it seems pointless to dissolve the argument to the level of how many angels can dance on the head of a pin, a phrase whose provenance I think is lost to time. And I think this represents a clash of two worlds, the ponderous nature of the application of law and the sometimes speed of light application of medical practice. Imagine you had a debate every time you've seen a newborn baby that had an elevated lactate or tachypnea or who needed a ventilator. What would you be telling the parents, or what should you be telling the parent? We will do our absolute best, but you should keep your expectations low or under promise and over deliver. But it's barely credible to me that we have reached this point in this argument. If we look at the provenance of the flitting rash in the Letby case, Dr. Ram said in evidence that he found this reference in a Lee and Tanswell paper and it caused a shiver up or down his spine. I can't remember which. And everything fell into place after he found the Lee and Tanswell paper. And as a consequence of him finding the Lee and Tanswell paper, the number of cases, reported cases of our embolus, according to what these judges say, rocketed overnight. So much so that we go from one description of this rash in the medical literature, which in my opinion was nothing more than a trick of the light, to now, a dozen reported cases that weren't recorded at the time they happened in any medical record on any baby. And having used phrases like shivers going down his spine and from Sally Kinsey, very striking and unusual, were now setting out to dim the perception of this flitting skin rash as having no more meaning to this trial than a sprinkle of fairy dust. It really is very sad to the integrity of medical practice. We have in evidence the wrong classification of disorder, the wrong description of disorder, the wrong pathogenesis, the wrong pathology, the wrong pathophysiology. But we're not remotely concerned with that when we really should be. During this trial, we had the profound absence of any concern about the permanent presence of pathogenic Pseudomonas, dodgy swipe data, and stable babies who were never stable, treated in circumstances they should never have been treated in. None of that is relevant to these lawyers now. They're playing a game as far as I'm concerned, and the response to this terrible tragedy in the UK has been everything but, let's put this right, let's do right by the parents. Millions and millions of pounds spent on lawyers, probably millions of bullshit words put into evidence, and everybody trying to cover their asses with utter contempt for the parents and the children. Sadly, I can't see it any other way. Sadly, despite the many advances in medicine, we continue to see these catastrophic events. And perhaps saddest of all, if we continue to deal with these tragedies in this way, we're going to see them time and time and time again. They will become, if they aren't already, as numerous as those angels on the head of that tiny pin. So we'll end this episode here, and in the next episode, we'll look at the judge's argument about Dr. Lee's evidence. So I'll see you in the next episode.